be seated. Good afternoon. Today we welcome you to the first court, and we have one case on the docket this afternoon. It is 0121-00731 Shafai Investments Limited et al. Versus Melania Estela Rivera Bonilla and Margarita Angelino Trujillo. Starting with appellant, counsel, please make your announcements.
Good afternoon, Justices. George Gibson here on behalf of the appellants.
Thank you.
Good afternoon. Sean Reagan on behalf of the appellees.
Thank you. And each side will have 20 minutes for argument. Does the appellant wish to reserve time for rebuttal?
Yes, I'd like to reserve 5 minutes.
And before we begin, just some housekeeping matters. When the light turns yellow, that means you have 1 minute left. And when it's red, of course, means stop. If you're in the middle of your question, you may go ahead and answer the rest of your question. And also, we have read the record and the briefs in full, so we don't need a recitation of the facts. It would really help us if you just dive in right into the legal issues. With that, we're ready to hear from appellant.
Good afternoon. May it please the court. I'm here representing Raj Shafai Investments and Party and Reception Center, Inc., which we'll just refer to as Shafai in general. They're all owned by the same family and the same people. We have, as Justice said, I'm just going to skip straight to the legal arguments, but I can provide any context to the facts that the court may need. We have appealed on several points, but the issues that I would like to focus on during our argument today have to do with the evidence to support the cost of repair damages, the evidence to support the mental anguish damages, the evidence to support the attorney's fees damages, and then also whether or not this is really a contract case as opposed to a tort case.
Can you please start with the costs? I think that would assist us.
Sure.
If you can start with necessity and reasonableness of costs.
Yes, Justice, I will. So thank you very much. There's been a lot of ink spilled between both sides, citing to dozens of cases all over Texas, including the Texas Supreme Court, about what evidence is needed in order to show a reasonable and necessary cost of repair. And both sides have focused on the cases that they want to focus on, and those cases sometimes come out in different ways, mostly depending on the particular facts of those cases. But there are several, in my view, rules or guidances that come out of all of them, and that is that the evidence must support that the repairs were both actually reasonable and necessary. Actually reasonable and necessary. It's not enough just to show the nature of the damage or the character and need for the repairs and the amounts that were charged. It's pretty clear that's not enough. Estimates and amounts paid are not sufficient to show reasonableness and necessity of cost of repairs to recover damages.
Well, how then do you get around our authority from 1986, the Gerhardt case, which, I mean, there's a paragraph right in that case where they go through and they say she got estimates, and that was held to support reasonableness.
Yes, I mean, that's right. And there are other cases where there are estimates that are obtained. There are other cases where the person testifying, usually it's a lay person, and that's where we come into these issues, rely upon, for example, databases that insurance companies use for estimating costs. And there's been a number of those cases that have said that that's not sufficient. Justice, the Gerhardt case in particular, that case went through and it talked about the qualifications of the witness. And it talked about how she had been a major in college in retail sales. She had worked for example, an oil field valve sales company in 2 retail stores. And she had been a buying and selling assistant. So in Gerhardt, the court said, okay, she got some estimates and she had some education and she had some experience that enabled her to be able to say, yeah, my opinion, my lay opinion, is that this is a reasonable cost. And that's really in stark contrast to where we are here today. And one of the things that I would respectfully request, I'm sure you've probably already done it, but I just want to emphasize it, is to please look at the line-by-line testimony as we laid out in our briefing, particularly in our reply. And the two plaintiffs just simply don't meet that same standard. They admit that they have no experience whatsoever in construction, no experience whatsoever in hiring a contractor. And in fact, as we laid out in our briefing in detail, and I can go through it line by line, when asked questions, even from their own lawyer, about whether or not the costs are reasonable, they also use the word fair, which is not the standard, but reasonable, it was, well, I just relied on the estimates, I don't know, I don't really know.
Well, Mr. Gibson, but the case law does not require that the person testifying as to cost be an expert. So asking that these witnesses have some knowledge or skill about construction would put us back into requiring some sort of expert testimony. One of the cases that is cited in the briefs is Gupta versus Mamwani from the San Antonio Court of Appeals. And that case does precede McGentry. However, the standard articulated is very consistent with the decision in McGentry. And in that case, the handyman or the contractor did not testify at trial, and this pertained to repairs of a rental property, and the owner was the one that testified. The owner did not have any specialized knowledge, yet the Court of Appeals found that the owner's reliance on the contractor was sufficient to establish the reasonableness of cost. Why is that not dispositive here?
Because my understanding of all those cases, I was trying to find my Gupta case and I couldn't put my finger on it right now, was that the difference is that they maybe relied on estimates or maybe they relied upon talking to people in the marketplace, but in every instance, as far as I recall, Justice, is that the person testifying had some experience or education or some reason in order to say, yes, these estimates were actually reasonable. And that's really, really different than the testimony here, is they completely disclaim any ability to assert. All they've really said is, I want to talk about the quality of the estimates in a moment, but all they really said is, I got 3 estimates and picked the lowest. That's not the standard. I'm not aware of any case that says that you're allowed to just get 3 estimates and pick the lowest, and that's per se reasonable.
Well, but we don't have a case that says that's unreasonable either, right? We're in this gray area and we're trying to figure out where we go from expert to lay witness and what evidence is sufficient. As I understand it, and correct me if I'm getting this wrong, but there was at least some evidence, and I understand there was some attempt to impeach it, but at this point we defer to the credibility of the witnesses as assessed by the jury. There was some, at least, evidence that both women had obtained some quotes and that they shopped around, right? They didn't pay the highest quote. They tried to shop around. They at least took some time to look at the type of work that the contractors had performed at other places, and they tried to negotiate, at least in one case, the prices down. Why is that not sufficient under the law? Because it seems to me that requiring much more than that would be putting a really high standard on people who are not always going to be sophisticated customers, who are going to have the knowledge and skill to be able to assess the reasonableness of construction costs.
Justice, I want to be clear that I think that there are 2 ways to prove up cost of repair damages. One is with an expert witness, someone that has the education, training, experience, specialized knowledge, etc., to do it. The other is, as we've said, the case law is clear, a lay witness can do it, but there still has to be some indicia, something that they did, something that they were capable of doing in order to render an opinion that this is reasonable.
Well, don't you think they did that here? They didn't just, the evidence isn't just, I got, estimates for $75,000, $35,000, and $30,000, period. It's, I talked to these people who were in our condominium complex at the time doing work, and the specific work they were going to do pertains to the damages caused by the flood. Doesn't that add that indicia of reasonableness there that gets us over the hump to legal sufficiency?
Justice, respectfully, I don't think so. And part of it is because of their actual testimony. They repeatedly said, I don't know. For example, Ms. Bonilla was asked, do you think it was a fair and reasonable price, the $18,000? Well, that's because he had to remove everything and it had been damaged and replace it. That's why it was fair. In other words, she said, well, because everything had to be removed, that's why it was fair. But that has nothing to do with the actual price. And Ms. Angelino was specifically asked, and did you think the $25,000 that you paid him was a fair price? Well, you see, I don't know a lot about construction. So after talking to those other two people, and they were charging so much, then I talked to this person, and that was more. And then asked again by her lawyer, do you think that what Mr. Castillo was charging was fair? I think so. I don't know about construction. This is the first time I was doing this, and et cetera, et cetera. And my point is that the actual testimony, they repeatedly disclaimed the ability to actually assert. I mean, they say that they took the lowest price. You're right, the record shows that. But none of the cases I've seen says that that's enough.
So you think this might be a distinguishing case because the witnesses actually testified, I don't know whether this is fair or not, but it's the lowest one I got?
Justice, I think so, because the cases I've read and the cases that we've argued about on both sides of this issue, as far as I can tell, every single one of them goes into the details of exactly what that witness did or didn't do, said or didn't say. And there's cases that come on both sides of this. I think that the McGinty case, which is, I think, one of the lead case or one of the lead cases from the Texas Supreme Court, is noteworthy because in that case, you had someone who was actually in the business of, I think it was pipelines, but I may have the wrong industry, I'm sorry. But he was in the industry, and that's what he did on a day-by-day basis with a significant company. And he submitted repair damages, and he based those repair damages about some databases that showed current prices. It's the kind of thing that business people rely upon in their pricing and procurement all the time. But the Supreme Court said, no, that's not good enough. And if someone who has that level of experience, even though they're under this standard a layperson, not an expert, and they rely upon data that the business people rely upon, the Supreme Court said, no, you can't just rely on that database, I don't think this comes anywhere close to that.
Can you address quickly, oh, go ahead, just to talk.
Just a quick clarifying question. From the colloquy here, it sounds like we're really focused on reasonable. Is there any serious dispute that the repairs were necessary? Or are we entirely focused on reasonableness?
So, Justice, certainly necessity is their burden to prove, okay? Clearly on both of these events, there was a 2015 flood and a 2017 flood, Harvey, and there's no dispute that there was flooding, and there's no dispute that there was flood. It is up to them to prove what actually had to be repaired. We are focusing mostly on the reasonableness of it, but with one exception, that Ms. Bonilla admitted that the $18,000 bid she got included betterments. They included some additions. They put in a patio to have some upper cabinets. And she said she had no idea. The bid wasn't broken out in terms of what each one was, and she had no idea how much of the $18,000 was for betterments, which I think clearly would not be recoverable, versus repairs.
So the jury did reduce that to 14 when they gave her the award.
They did, but there was no evidence in the record whatsoever to show that that $4,000 reduction was as a result of that. I mean, that may be what the jury was trying to do, but nobody knows that.
Okay.
Mr. Gibson, since you're running short on time, can we transition to the economic loss rule and the mental anguish damages that were awarded in this case?
Yes. I find that this rule can be, in my practice, a bit hard to apply because there is a clear rule that says that if the damages you are seeking are to whatever it is that you were bargained for, what you paid for, then that's a contract claim, not a tort claim. But yet there are clearly cases that talk about, well, but if you allege these other elements of fraud or misrepresentation, et cetera, it can come out of that exception. In this particular case, it is really, really clear that what they were seeking at all times was the insurance coverage that they say they paid for. and that those are the only actual damages that they presented were for that. And they and that's and that's question number one, was what did Shafai agree to provide insurance in exchange for those monthly payments? And the jury found yes. It was hotly contested, but that's how they found.
So your argument is that there's not a separate injury or recovery that would justify the treble damages under the DTPA?
That's exactly right. That all the cases that analyze this based on those particular fact patterns all say you look at the nature of the injury requested. And in this case, and in fact we cited to some of the testimony and some of the argument that where they said, okay, so what are you asking for? Like, I want the insurance. I want to be repaid for the cost of repair that I would have had if you had purchased the insurance.
What is your understanding as to, in looking at the judgment, and I'll be honest, I'm trying to figure this out, what is your understanding is the actual basis of the treble damages? Is there a specific cause of action? Was it the Texas Collection Act? This is the DTPA. Are you able to map it out or understand how the judgment came to that conclusion?
I would have to look at the charge again. I don't remember what the conditioning instructions were on that particular question for the additional damages. I think it was tied to DTPA is what my recollection is. I don't think that the judgment is actually really clear on that. As to whether it's tied to DTPA or something else, but my best answer to you, Justice, is the DTPA. But
well, you have to elect a remedy, right? And this is a question for Appellee too when they get up. But what remedy did you elect here? Is kind of what I'm interested in.
Right. I imagine the answer is going to be DTPA, but I assume Mr. Reagan can answer that for himself. But that's what I would imagine the answer is. My time is up. Is there anything else?
Any more questions?
Thank you.
Thank you. Mr. Reagan, we're ready for your argument.
May it please the court. As to the reasonableness of the repair damages, there's a lot of discussion, a lot of briefing. I won't rehash the briefing, but there is a case from this court about 3 weeks ago. Now, I butcher the name. It's Demiraj, D-E-M-I-R-A-J versus Martinez.
Say that again.
D-E-M-I-R-A-J versus Martinez.
Thank you.
And in that case, it was another Hurricane Harvey case. An elderly couple, I believe they were in their 80s, their house got flooded. They hired a contractor. They agreed to pay him $117,000. Inevitably, dispute arose. The contractor was fired. About half the work was left. So the plaintiffs got a replacement contractor. That, I believe, is called All-Star Contractors or All-Star Construction. So they charged them $45,000 to finish and remedy the defective work. So at trial, the elderly gentleman, the husband, he testified that the $45,000 was reasonable because it was about half of what the original contractor charged. Half the work was done. The original price was $120, $117. $45 was less than that. And it was also less than what the original contractor said he needed to finish the job. More importantly, his daughter testified, and this court held that her testimony was sufficient. And all she said was, what we paid the replacement contractor, the $45,000, was in line with what other contractors were charging. That's it.
But do we have that testimony here? I suspect that Mr. Gibson would argue that the testimony here falls short of even that testimony you've just quoted from that case.
I think obviously we think the evidence in this case is much more robust than the Martinez case. We didn't just get 3 or 4 estimates and pick the lowest price. We laboriously detailed the process as called for at McGinty and Laguna Tubular. How many bids did you get? Who did you talk to? What did they say they were going to do? They were going to take out all the damaged sheetrock insulation, stuff like that. Did you go look at other work these contractors were doing? Did you like the work they were doing? Did you think they were competent? Did you think they did a good job in doing your work? Did they do it on time? Yes, 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 yes. And contrary, there's a lot of discussion that's about fair and reasonable, but we don't need to use, the cases are pretty clear, the buzzwords reasonable and necessary are not required.
I'm having a hard time, though, understanding how those estimates weren't hearsay.
Well,
And I don't think a lay witness can rely on hearsay. I know there's some case law that maybe suggests it can, but I don't really buy that. If it's hearsay, why was that admissible?
we don't believe it's hearsay because they have independent legal significance, just like a contract is not hearsay. So for the bid, the actual contracts they sign with the ultimate contractors, those are not hearsay as a matter of law because they have independent legal significance. The estimates, the receipts are not hearsay because they're not offered to prove the truth of the matter asserted that the actual work that was done was reasonable and necessary. It's just to show you the process of what we did. And there are cases, they're usually the car repair cases, which is similar to home repairs. You know, this is something we're all familiar with. We're familiar with our home, we're familiar with our cars. And it makes sense that you could be able to rely on hearsay because it'd be awfully difficult if you had a $6,000 car wreck with no insurance, let's assume, that you would have to call each mechanic and bring them to trial to testify. That would be, you know, pretty difficult to do. And
Well, typically you would prove those up as business records, though. Was that done here?
no, but that actually it supports our position because if we went to Mack Hike Chevrolet or Tommy Vaughn and got their mechanics invoices or proposals or bids and a business record affidavit, the custodian of records doesn't have to have personal knowledge of what's in the
Why
bid.
couldn't they just do a deposition on written questions and submit that?
Say again?
Just do a subpoena ducis tecum or a deposition on written questions. You wouldn't have to call them into trial.
But we're talking, if we were proven up as the business record affidavit, either a subpoena or a deposition of written questions, it still would have the custodian of records, and the cases are, you know, legion that you don't have, the custodian doesn't have to have personal knowledge of what's in the estimate bid or
But
proposal.
my contractor statement, this would have cost, I'm going to quote you $35,000 to do the repairs necessary for damages caused by the flood, and then the plaintiff's testifying to that. I don't see how that's not inadmissible hearsay presented for the truth of the matter asserted. I mean, the truth of the matter asserted is this is the quote we got for this price. That's the reason it came into evidence.
The estimates, the contractors that weren't hired,
That weren't hired, correct.
their estimates were offered to show that they were actually made and that she shopped around. They weren't offered to prove that the repairs that were ultimately done by someone else were reasonable and necessary. It was just to provide a basis for her lay opinion, which she has to do through some way. And the cases say we can rely, a lay opinion can rely on hearsay. And we think it's sufficient there. But to go back to Mr. Gibson's, it says about the fair and reasonableness testimony. Ms. Bonilla had it twice, and she testified that Mr. Martinez's estimate was reasonable. Same for Ms. Angelino, testified it was reasonable. So yes, there was some confusion, unsophisticated plaintiffs, translation issues, but they testified repeatedly that Dr. Work was fair and reasonable. And they don't have to know how to build a house or do repairs. The cases show, just like the Martinez case we talked, they just have to know how to shop for repairs. If you're doing a car repair, shop around, call a mechanic shop, call collision centers, ask get an estimate and compare those. And if you look at the cases that are briefed, particularly the McGinty case, the Supreme Court agreed with Justice Frost's dissent, and she criticized the plaintiff in her dissent for not getting competitive bids. Same thing in Knight Renovations. They relied. The plaintiff didn't get a bid, did not get competitive bids, or he had one estimate. The Petrovic case, he didn't bring the estimate he got. So in this case, we actually went out and got 2-3 additional competitive bids, and they picked the lowest one. This evidence is more than sufficient to support the reasonableness and necessity of the amounts awarded.
Can I shift gears for 1 second on this? So we have an estimate in the case from Ms. Bonilla, from Mr. Martinez. It's for $18,000. It obviously, in the estimate itself, includes all sorts of stuff that is not caused by the flood. You're claiming that it's Harris County versus Smith Castillo error in the jury charge, but Harris County versus Smith type Castillo error in a charge, Castile error, is where there's multiple theories of damages, and one of them is legally unrecoverable. Here we only have a single element of damages, which is the reasonable necessary cost of repairs caused by the flood. Why wasn't it the plaintiff's burden to break this down and to show the jury, give the jury a way that they can determine what of these repairs were caused by the flood and what are upgrades or betterments?
Sure. Well, as Mr. Gibson said, these were betterments. Texas Supreme Court 1950, Pasadena State Bank. If the issue is one of betterment, it is the defendant's burden to prove the existence of the betterment and the value added. That wasn't done. There was no pleading of betterment. There was no jury question. There was no jury question submitted.
Well, the betterment though would go to something that's damaged, and then you do a repair to it that makes it better than it was. Here, I mean, the patio, that had nothing to do with the flood at all. That's not a betterment. That's something that's tacked on to this $18,000. And I assume what the jury probably did is just reduced it by $4,000 and went from 18 to 14,000 to make up for that. But what gave them a basis to do that?
Sure. Well, I don't know what the jury actually did.
Right.
But if we're looking at it, the Burbage case, the Harris County case, the Thomas case, the Martinez case, I believe, if you have a complaint about a specific component or element of damages, it was their burden to object to the charge and point out the lack of segregation, the lack of a question. Now, all they did with regard to questions 19 and 21 was assert, as they did with every other question, by the way, a general boilerplate legal and factual sufficiency challenge. So if they maintained that these damages included unsupported or invalid components, theories, or elements of damages, it was their burden to object to the charge and specifically say these items don't belong. Furthermore, if you even consider their boilerplate objections, they're obscured by 35 pages of the same objection to every single question.
Can you point to any testimony in the record from Ms. Bonilla where she tried to parse out what she would have paid for these add-ons for the jury to determine that that should be separated from any damages awarded for necessary?
That's not in the record. I think she says she doesn't know. So.
Okay, here's my question.
Sure.
What theory of recovery did you elect on in the judgment?
Well, it's different from each lady. So let's start with, I've been doing Bonilla first, Angelino, somebody said A, B, and made it a lot more sense. So for Angelino, it's a straight DTPA claim. That is the element, that's the element we recovered under. We also had, breach contract fraud, statutory fraud for Ms. Angela. But
and when you're answering this, also answer to us whether or not it's a straight DTPA on DTPA only, or if it's a DTPA tie-in to the Fair Debt Collection.
For Angelino, it's solely DTPA. That's the theory we elected for her on the judgment. For Bonilla, we had the tie-in with the debt collection. That's where the middle language came from. Mr. Shafai and his lawyer accusing her of committing a crime, putting the house up for foreclosure. But she also recovered her repair costs from the 2015. So it's a little confusing because there's two different tracks for Ms. Bonilla, two different floods, by the way.
Okay, so backtrack.
Sure.
First, there. Angelino first. DTPA claim. Why is that not impacted by the economic loss rule? What independent injury does she have other than the loss of insurance for her property, which resulted in her remedial costs?
Sure. Just to take a step back from that, if you look at the Chapa case, and the A-Sign case, and the Delaney case, and the Jim Walter case, the question really is, was this just a mere breach of contract? Or is there some fraudulent inducement or some fraud, say Formosa Plastics, that takes it outside of the economic loss rule? And this is very important. We look at the charge. Questions 9 and 10, the DTPA questions, included in section 2 that the jury agreed. And these challenges, these liability findings have not been challenged on appeal. Section 2, the jury found with regard to Ms. Bonilla and Angelino that the Shafai defendants failed to disclose information about the agreement that was known at the time with the intention to induce the plaintiffs into a transaction they would have otherwise not entered into.
But that to me ties back, and the representation was, I'm going to provide insurance for your property, and Mr. Shafai allegedly did not. So it all ties back to this breach of contract issue, right? I'm having a hard time figuring out what's separate, what's different. The key here is, the allegation is, I was told that I was going to be given insurance together with my payment for this property. And that turned out to be a fraud, a lie, a breach. But it comes back to the same issue, which is they were not provided insurance. The economic loss was the remedial cost that they had to pay out of pocket. So how is there a different injury that would give rise to separate damages that would not be barred by the economic loss rule?
Well, for one, we have the mental anguish damages that the jury agreed with us on and awarded. But to go back to those cases, there's a difference between I paid you to run the Yellow Page ads, you just didn't do it, as opposed to I paid you to do the Yellow Page ads, you took my money, but you never had any intention of performing. You defrauded me, you fraudulently induced me in the contract. We have unchallenged fraud claims, fraud findings by the jury that included a subsection about did they have no intention of ever performing. We have statutory fraud. They never intended to perform.
But you didn't recover on those. You didn't elect to recover on those.
We did not elect to recover on the fraud and statutory fraud, correct. But if the DTPA is reversed for some reason, we can elect to recover on the next best item, which would be fraud or statutory fraud.
Isn't that a little bit separate? I agree with you that you have these independent findings, but as a matter of law, we need to determine whether, regardless of those findings, the economic loss rule applies to that type of recovery. So you may have the findings, but that doesn't mean you get to recover under both if the economic loss rule would apply and, in essence, bar recovery under those affirmative findings from the jury.
Like in CHAPA, there was a sale for a car, but then there was an independent deceptive misrepresentation about the quality of that car. What's your separate, deceptive act here, separate and apart from I didn't fulfill my contractual obligation?
I don't read CHAPA that quite narrowly. I read it as, hey, if you can show some extra contractual tort, i.e. the defendants never had any intention of performing their agreement, because we have an independent duty. Remember, the source of the duty. Is it the contract or an independent duty imposed by common law? We all have a duty imposed by common law not to defraud each other in our business transaction. That's how I read CHAPA. That you have an independent duty to not defraud me, and if you never had any intention of performing, which the jury found in this case, and that hasn't been challenged, that takes it outside of the economic loss rule. And as for the damages, we also have mental anguish caused.
Wait, hold on,
Sure.
I'll go there. So let me transition So now with Bonilla, though, then you have the Texas Fair Collection Act, so that would be different. So you would say that's what would support then the treble damages under the DTPA tie-in through the Texas Fair Collection Act. Is that correct?
Thank you for reminding. Yes, the debt collection findings would also take it outside, for Bonilla, would also take it outside of the economic loss rule, because those are independent duties. They created misrepresentations, they violated the statute. So that's a little different. That wasn't just a mere breach of contract. These are affirmative actions they took in violation of statute, accusing her of committing a crime, posting up property for foreclosure without the proper notices, and so on. So at least for Bonilla,
will you agree with me that those are two separate events? One is all the cause of action stemming from I didn't get the insurance when I told you I was, and then totally separate and apart from that is Fair Debt Collection Act. I told you that I was going to foreclose on your property and put you in jail. Aren't those two separate, essentially, cause baskets?
Correct.
Okay.
So Bonilla had claims that arose in 2015, and she had claims that arose in 2017, 2018 with the foreclosure. Correct.
Okay.
Okay, now, mental anguish. Can you map it out for us? How do these mental anguishes get awarded, and based on what cause of action or finding from the jury?
Sure. The mental anguish damages could be supported by the DTPA for both plaintiffs, Bonilla and Angelino, by statutory fraud and fraud. Additionally, Ms. Bonilla can recover mental anguish under the Texas Debt Collection Act. So those are the legal bases for the recovery of those mental anguish damages.
Okay, now tie it to the testimony, though, because not all of them testified that the mental anguish was caused necessarily by the 4 acts that would be the basis for those causes of action. For example, to give you one example, Ms. Bonilla testified that she was distraught and had some anxiety because of the collection efforts and the accusations, right, that were coming from the collectors. That's separate from insurance. That's separate from fraud. So talk to me about the testimony that was actually elicited from each witnesses that would support the mental anguish and what cause of action it tied to.
So with Ms. Bonilla, yes, primarily, yes, that was the focus of the trial. My recollection is the mental anguish was focused on the debt collection violations in late 2017 and early 2018, and put her through the ringer through the foreclosure. I would have to go back and look at the record, but she's consistently testified that she's had issues with Mr. Shafai throughout the entire time. But I would agree, for Ms. Bonilla, the primary focus of her mental anguish was caused by the debt collection violations and the wrongful foreclosure action, not the wrongful foreclosure, the debt collection related to the attempted foreclosure. But for Ms. Angelino, it was directly related to post-Harvey flooding and not having the insurance. And to go back, one point I do want to make about the repairs before I forget. The Shafai defendants, it's a little confusing. Some of these townhomes are in the company name, some are in his individual name. But he owns the majority of the townhomes in the complex, 50 of the 96. He testified that he was familiar with the cost to repair his townhomes because he had to repair it like everyone else did after Harvey. And he did repair the 50 townhomes he had out there. But he did nothing to controvert their testimony about the reasonableness of their estimates, the reasonableness of their damages of their claim. He could have readily controverted it. And when he was asked, do you disagree or do you agree that these damages that were being sought are reasonable, he said he didn't know. So if we go back, to pull back a little further, you got to remember this is a jury trial. The jury is weighing everyone's credibility, judging the witness's demeanor, and so on. So you have one hand, well, these ladies don't really know enough about construction. Well, the jury can take that into account and determine their credibility, whether or not to give weight to their testimony. And obviously the jury took off 22% of their requested repairs. So the jury did do something. But on the other hand, he had the opportunity to rebut it. Like, well, I repaired 35 of these same 900 square foot townhomes. It only cost me $10,000. He didn't do that. He could have readily controverted with his own evidence. And he just said he didn't know. And the jury probably didn't find that was credible, in addition to all the credibility issues we raised in our brief throughout the trial. And I think that's very important for the court to know. And finally, as to the attorney fees, I think the briefing is pretty clear on that. There was no objection to the lack of segregation. Again, we had a boilerplate legal factual sufficiency objection. Factual sufficiency is not a proper objection to the charge. But even if you consider the legal sufficiency challenge, it was obscured by 35 pages of the same objections to every single question. If there are no other questions, I ask that you affirm the judgment.
Do you have any questions?
Oh.
Let's talk.
Thank you.
Thank you very much. Appreciate it. We're ready for appellant's rebuttal.
Thank you. I'm going to hit a couple highlights and, of course, answer any questions. Going straight to the new case that Mr. Reagan referenced, I looked it up, and of course, I admit I have not studied it because I was trying to listen and read at the same time. But the Demarriage versus Martinez came out about 3 weeks ago, and it does deal with cost of repair. But I need to read it more carefully, but I would urge us all, because I really think that this is another one of the examples of each case is really unique on its own damages. For example, in this case, it was actually about a remititure. It said the evidence is not sufficient to support the trial court's full award of 98 some odd thousand in actual damages, but is sufficient to support a part of that award. And so it goes on. And it also talks about how thus, regardless of whether the opinion testimony of Noe and Baumann, which I think are the two people that testified that he referred to, the record contains other evidence. And so I haven't studied this, so don't pretend to know it, but I would just urge that I don't really think that this says that if you have a layperson that just comes in and testifies that they think this is reasonable, that really supports their case. So, but going
Can I
back
ask you just on fees, because that's where we ended. How did you preserve that issue for our review, segregation of fees?
Segregation of fees. So we, as soon as Mr. Reagan testified, he testified in a narrative format. In other words, he didn't ask questions of himself. He testified about his fees. On cross-examination, I immediately, the first thing I asked him was, did you segregate? And his answer was that you can see the exact answers, but it essentially was he didn't, but he thinks it would be about 95% recoverable. And then I asked him, well, did you do any analysis of that? Did you do any study? He really didn't. We then, we then brought this up in post-trial briefing. We also objected to the sufficiency in the charge. And there's case law, we've cited some of it, and I could cite it again, that talks about how in terms of preservation, you can preserve error by examining a witness, for example, on their segregation, by objecting to it, and by your post-trial briefing, which is what we did. So I think that that covers it. Quickly on the DTPA issue, we briefed the Johnson case. It is not of this court. I believe it's Eastland, if I remember correctly. But the reason why, Beaumont, and it's 2014. The reason why we briefed it is because the facts actually align somewhat like this. And it was a situation where the homeowner had paid the premiums and believed to the bank and believed that they had coverage, and it turned out they didn't. They were hit by, I think it was Hurricane Ike, and they alleged not only breach of contract and misrepresentation, and the court found, no, you're really just seeking the benefit of your bargain. And so, again, I understand Beaumont is not Houston, but I think that the analysis is instructive on the contour DTPA economic loss issue.
What about us to the Texas Fair Collection Act? Because Bonilla chose to recover under that claim. Why would that recovery be barred by the economic loss rule?
So it's interesting, I think, because the tie-in questions for, I think, all of the damage questions tied into all of the theories. So in other words, the repair costs were sought as part of the DTPA liability. And it said if you answer yes to any of these questions, and it was contract, fraud, blah, 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 including the debt collection.
Well, I think that might be where Castile does come in here, and if, they wanted to segregate those questions out, and they could have been, but if they're all premised on or predicated on, all the findings of different cause of action, then I think probably the jury was allowed to answer it that way.
Justice, my point in responding that way was not on Castile, but just it goes to the issue of, okay, what injury are you seeking to recover for? And my point is that shows that even under the debt collection claims, they were seeking to recover for the very same insurance costs. That's my point. And so therefore, if the nature of the injury here, which is I didn't have insurance to repair my home, was also a grounds for the debt collection act.
There was another ground also that they're threatened to be foreclosed on and thrown in jail, and that's separate and apart from the contractual issue.
I do agree that was part of it, yes. And that so as to, yes, I do agree that that's separate and apart from the insurance issue. But again, I think it was all tied into the same thing.
Okay.
Justice?
Back on the Johnson case you just mentioned with the claimant was paying the bank and didn't really have insurance. Was there any element of fraud in that case or any element of any other wrongdoing in the contract?
Yes.
Okay.
For example, it says the misrepresentation that Johnson claims BOA made was that BOA misrepresented that it would timely pay the premium to renew her windstorm insurance. And this representation was nothing more than a representation that he would fulfill its contractual cost. So that's why I say I think that's really similar to what we're talking about here. Jumping around as usual.
Well, I have another question for you. Opposing counsel brought up in his argument the idea that perhaps Mr. Shafai, when he was testifying, could have put forth some evidence or even a somewhat knowledgeable opinion that the damages presented were unreasonable, and instead he said he didn't know. Do you have any response to that?
Yes, because it's their burden of proof, and we denied all their claims. And when he was asked about it, Mr. Shafai said, "I don't know." He didn't say, "Yeah, I think they're." If he had admitted that he thought they were reasonable, that could be an issue. He probably wouldn't be here on this issue, but he didn't. And I would say, Justice, that was their burden, and so if he just said he doesn't have a testimony on that, then I don't think that would weaken our argument at all.
Any further questions? Well, thank you both sides. We appreciate your arguments and your briefing. The case is now submitted and we are now adjourned.
All right.
2019.